We're starting the final lecture of today. Now I have the honor to introduce the lecturer of our last session today, Professor Phoebe Okowa. Professor Okowa is a lawyer. She teaches in the Queen's Mary University of London and also is a member of International Law Commission. She has been teaching and practicing for the past 30 years. The topic of her lecture today is the role of the Ilc in the codification and the progressive development of international law. Please.
Thank you very much. Good afternoon, everyone, and it's a huge pleasure and honor to be here today. It's a pity we have limited time, so I will not. It would have been nice to sort of first go around and have an introduction so that I understand where you're coming from and your previous engagement with international law. But given the limited time we have, I hope we can reserve some of those questions either to the end or during the reception, which the Ministry of Foreign Affairs has generously organized for this evening. I chose to talk, or I was asked to talk about the role of the International Law Commission in the codification and the progressive development of international law. Now, one of the things those of us who are members of the Commission get asked from time to time is that we don't do enough public engagement in explaining to our key constituencies what exactly the International Law Commission is, what it does, and that in fact they only see us around the time, the periodic 5 years, when we seek a fresh mandate or to be elected to the International Law Commission. So I decided, in the context of today, I was given the freedom to decide exactly what aspects of the Commission's work I wanted to talk about, to do two things. First, to give a very broad overview of the nature of the International Law Commission, its core mandate of codification and progressive development, how it discharges that core mandate, and the challenges in the discharge of that mandate. In the second part of my talk, I will talk about a particular project which is in the Commission's current program of work, immunity of state officials from foreign criminal jurisdiction. So that is now on second reading. It is the longest topic on the Commission's agenda, the Commission having adopted it on its current program of work in 2007. They've had no less than 3 special rapporteurs. It remains controversial, both within the Commission and in the 6th Committee of the United Nations. So I thought it would be a good particular topic on which to focus. Of course, all the Commission's topics are interesting and important, but for reasons of time, I thought this is something that we all may want to engage with, both here and in the context of the practical work in which you do in your foreign ministries or Attorney General's offices where you work. Now, the first thing to note is, of course, the International Law Commission was set up in 1947, around just soon after the setting up of the United Nations itself. But what is interesting to note is that codification of international law as an enterprise, as an exercise, is of very recent development in the international field. In fact, diplomatic codification of international law itself has very few parallels in the modern history of the United Nations. The reasons for this are varied. Likely because in the period before the United Nations, codification existed, but primarily as an academic exercise. Some of you may know about the Institute of International Law or the International Law Association. These bodies had been involved in codification exercises, but primarily as an intellectual ideal, as an intellectual aspiration, which had very little connection to the practical needs of states. So as a result, they made no impact. They produced many documents, many learned texts, but many of these did not have much impact beyond those specific academies. One reason for this is that for much of the period until the period of the League of Nations, there were no organized foreign ministries or secretariats. So there were no institutions that could act as a bridge between the academic study of international law and its practical application. And if you think about it, in the context of the practical work you do, you have not much interaction with what academics do. In a way, you need a connection between that academic study and the practical application. So these two associations, which remain in force, remain essentially learned societies. And the emergence of foreign ministries and secretariats in international organizations, which could act as a bridge between the academic study of international law and its practical application, meant that codification became a very useful exercise. The other broad thing to note about codification generally is, in most legal systems, codification is the last exercise. One argument is that international law itself is very much a rudimentary, or was a rudimentary, primitive system based on state practice, custom. But until that custom has evolved and coalesced, you don't get to codify it. So that in domestic legal systems, in all legal systems, codification is always the last project in the development of any legal system. So in a sense, international law was not ripe for codification. It becomes ripe for codifications once we have a significant body of practice. And so it is interesting that although the drafters of the League of Nations had in fact anticipated the need for codification, and a committee that drafted the Statute of the Permanent Court of International Justice, the precursor to the League of Nations, had anticipated the codification of international law, there was not much political appetite. It remained very much an ideal that did not take root until the Charter of the United Nations in 1945. So at San Francisco, it became very clear to the states that had gathered at San Francisco that if war was to be prevented, if states were going to be encouraged to engage meaningfully in the peaceful settlement of disputes, then they needed clear rules that could be applied easily and effectively. And so codification assumes center stage in the drafting of the United Nations Charter. You will see that Article 13.1 of the Charter itself provides that the General Assembly shall initiate studies and make recommendations for the purpose of encouraging the progressive development of international law and its codification. Does anyone want to have a guess as to why the phraseology is in the way in which it is? It talks about codification of international law and progressive development. Actually, in Article 13.1, progressive development appears before codification. What do you think is intended? Because essentially, the mandate of the International Law Commission in its statute is to assist the General Assembly in the codification and progressive development of international law. What do you think is meant by that twin mandate? There's a mandate to codify and a mandate to advance the progressive development of international law. Does anyone want to have a guess? Essentially, that's all the International Law Commission is about.
Progressive development could mean looking into the areas of law which had not quite been discussed before, say, for example, air and space law in recent times or cyberspace. It could mean that. And codification could purely be for the law which has quite ripened, maybe those customs which are ripe and which need to be just codified. Mm-hmm. So I think that's the difference.
Yes, broadly correct in the sense that the progressive development was intended to assist the General Assembly deal with those areas of the law in which the law was still not yet developed. So in a sense, it could be creation of new rules or advancing those rules that were still inchoate, not fully developed. And in fact, in the earlier periods, with what International Law Commission calls the golden age of codification, almost everything had to be created. We need the need for rules on diplomatic immunity, needs for rules on the law of treaties. So there was a lot of, and sometimes a specific mandate. The ECOSOC specifically asked the International Law Commission as one of its first projects to come up with a draft convention on genocide. Because there was no crime of genocide as such. Even at Nuremberg, no one was prosecuted for it. So the mandate was essentially to think and create de novo from scratch a convention on genocide. So the idea was to anticipate that law was not ossified and that the Commission must be able to adapt to the needs of the international society, hence the mandate. And in fact, in Article 13.1, you will see that progressive development actually comes before codification. What? Yes, sorry, can I I'm assuming it's on. Can you hear?
As you rightly explained, Professor, the two terms are properly organized because first is the legislative process, and second, it comes the need for codification. Mm-hmm. Because especially in the international community, it can happen at the national level, but in the international community, treaties are done on a regular basis. Sometimes treaties overlap. Sometimes there are a number of treaties dealing with the different similar issues. So at one point in time, the need to condensate and compile and organize them comes, and then is where codification comes.
Yeah.
Yes.
So in a sense, the essential difference between progressive development largely is an attempt to create the law where there's very little. In many cases, of course, the Commission, as created by its statute and lacks a democratic mandate from UN members. So it cannot create law unless requested by the political organs. That was a necessary democratic limit. There are 34 members whose only expertise is law. So at the end of the day, even the progressive projects of the Commission will still need the political imprimatur of the political organs of the United Nations. So that's why, in relation to the progressive development, something I hope to talk a bit about, is that the power of initiative lies with the General Assembly or with the United Nations political organs. The Commission cannot create law in itself from scratch. But codification was intended to be a scientific, systematized way of bringing together all the rules of practice that had evolved over time, right? So in a sense, much of international law is still based on custom, on practice, and the idea behind codification was that once that practice had reached an advanced stage, the Commission could undertake the scientific process of bringing that practice together, right? So in a sense, the idea was essentially to codify what states had agreed on. And in relation to codification, because the Commission was not creating law from scratch, but rather bringing together the practice that states had been agreed on, both the Commission and the General Assembly could have the power of initiative, because essentially what the Commission is doing is putting together what states have agreed on. In relation to progressive development, the point to remember is that there's a necessary democratic limit to what the Commission can do. It cannot create law from scratch unless requested by the political organs. Now, in practice, the distinction between those two aspects of the Commission's mandate are not as stark as it may seem. One is that if you're going to systematize rules and collate them and bring them together, any process of codification will, of course, involve elements of filling the gaps. Think about it, whether it's in domestic law or any process of bringing the law together, systematize it, will involve aspects of progressive development. It is interesting that the Committee of 17 that was set up at San Francisco, the committee that was responsible for creating the International Law Commission, was very alert to this fact, that the distinction between codification and progressive development will not always be that stark. That codification will always involve elements of thinking about what the law might be, or what are the omissions, or what are the failings in the law. Secondly, it has also become very clear that no topic is completely new when it comes to the Commission. Even in relation to genocide, the ideas behind it were already there in the practice up to 1947, 1948, when the convention came into being. So no topic is completely new when it comes to the Commission, that almost all topics will involve elements of progressive development and codification. But what the Commission lacks is, in the absence of a specific request by a political organ, is to undertake lawmaking which has not been supported by practice. And I think here parallels are not that different with domestic law. If you want to introduce a radical change in the law which has no parallel in your domestic institution, you don't ask your law commission to do that. That is a matter which only Parliament can do. The law commission may provide a draft if requested by the political organs, but the ultimate decision on how that is implemented will rest with the political bodies. So in a sense, much of the work of the Commission has pretty much followed those twin approaches. Some aspects have involved codification of the law, some aspects have involved progressive development, and most recently, the Commission was requested by the General Assembly to look at the question, the impacts of climate change, sea level rise on many aspects of international law, including maritime boundaries, including statehood. But it needed that specific request to essentially deal with things in respect of which it was not quite clear that the practice had fully developed. But both involved both aspects of codification and progressive development. Any questions? Now, just very briefly, in terms of composition of the Commission at the moment has, anyone want to guess, 34 members. In the original intention to create the International Law Commission, and you will know more about it because the next elections are in 2027, so members of the Commission will be knocking on your doors asking for support. The Committee of 17 that created the idea of the International Law Commission and came up with the Commission statute had actually intended it to have just 15 members. And the idea was that these 15 members was enough to ensure geographical representation and adequate expertise. But over time, the statute has been amended many times, and so that today the membership stands at 34. Can anyone explain why the membership has increased to 34? Between 1948, 47, and now, we have 34 members. Yes?
Yes, Professor, I think it's because of the rising as well as the emerging new countries, especially in the Asian and African region, in which they were not yet there in 1945.
Correct. So as the statute, as the membership of the United Nations expanded, the need arose to make it more representative. In fact, for much of the period between 1947 and early 60s, the Commission was very much a Western European institution. But as a result of the processes of decolonization and self-determination and the emergence of new states, there was a need to make the body as a whole more representative. And the Commission pretty much operates on the basis of geographical distribution of seats. Africa has 9 seats at the moment, Asia has 8, but 1 seat floats between those regions. So at the next election, Asia will have 9, Africa will have 8. Western Europe has 8. Latin America has 6, and Eastern Europe has 3. Those are pretty much rigidly set up in the statute, the fact of geographical distribution. Now, during the drafting of the statute of the International Court of, during the drafting of the United Nations Charter and the statute of the International Law Commission, there were heated conversations as to how members of the Commission should be elected, whether the election to the Commission should be based on technical expertise and scientific competence, or whether or not there should be deference to the political needs of states. In other words, what role should states have in this new body? There were those who felt that qualities of statesmanship, questions of political affiliations, should have less significance in a scientific body whose primary role and purpose is to advise states on the codification and progressive development of international law. There were those who felt, though, that the body as a whole must reflect political realities, and that since the Commission was going to be a subordinate body of the General Assembly, it must show appropriate deference to the political actors within the international system. So the approach you find in the statute is actually a compromise. The compromise is a nod to the fact that this is a subsidiary organ of the General Assembly and that must show appropriate deference to the political composition of the United Nations. So elections are on the basis of nomination by states, right? But there is a qualifier that members of the Commission as a whole are required to demonstrate appropriate expertise on matters of international law. In this sense, the requirements of competence are not that different from those required of judges of the International Court, that there must be persons who have learned, qualified, competent in matters of international law. There's been some conversations that because of the way United Nations elections now operate, the fact that states have to lobby, the fact that there are already political understandings on how these votes are taken into account, that qualities of statesmanship and political considerations seem to matter more than technical expertise and knowledge in matters of international law. But many have felt that perhaps this is a necessary compromise in respect of a body which ultimately the significance of its work only matters to the extent that states essentially engage with that process. So those are the key questions of the considerations in relation to composition, that essentially members have to be nominated by states, that election is a very politicized process, but once members of the Commission are elected, they serve in their individual capacities, and the idea was, of course, also to make sure that they cannot be subjected to pressure by states. Practically, this has happened, following the Republic of China's member. Russia objected to the Republic of China's member in 1950, Mr. Hu, sitting in the Commission, and the view was taken that he was an independent member of the Commission who could not be forced to resign just because of the internal political problems within People's Republic of China and the Republic of China. So there is a degree of insulation and immunity from those kinds of political pressures, but it remains very much a political process in terms of election and in terms of, in terms of its mandate as well. Any questions? Yes.
Thank you for a lecture. I'm Yotaro from Japan, and I'm currently doing the master's program at the Geneva Graduate Institute in Switzerland. And I've got a question regarding your thoughts as a member of the ILC. So one of the reading assignments you assigned to us for this lecture, the article written by the Professor Alan Pellet. And in his article, he says that when it comes to the selection of the committee member, he says the professors come from the West, while the diplomats are from the third world. So you're invited to the ILC member, and you're a professor, not a diplomat, but you comes from not the Western country. So how do you see yourself as an academic who comes from the not non-Western countries? And one additional question is, this article was written in 2004, so is that situation situation changing recent days? Thank you.
Yes and no. I think the composition of the commission, so on the question whether or not the professors come from the West and the diplomats come from the developing world or the global South, I don't think it's entirely accurate. Obviously, it depends on the membership of the commission. There is a feeling, and someone will have to do an empirical study, that there is a shift towards having more statesmen and more diplomats in the commission than academics. And that in a sense that some argue that this may be problematic, in the sense that some of those diplomats in the commission are also serving members of their own countries, foreign ministries, or attorney general's offices, and in fact sometimes attend the Sixth Committee as delegates of their states. Now, if you think about it, the commission was intended to be an independent body advising governments on questions of international law, showing deference to the Sixth Committee. So a twin process was intended, a process whereby a technical body of legal experts, and in fact, pretty much with a few exceptions, the only expertise we have is law. So in some sense, there are many things that are beyond the competence of the International Law Commission. You know, if you want a very radical treaty, like the pandemic treaty, maybe the commission is not the right place for it because you need doctors and you need those with expertise in pandemics and not just lawyers. So there are arguments about limits to what the commission can do, but there are genuinely concerns that in a sense, if in fact there's a double hatting in terms of membership of the commission and the Sixth Committee, then the commission may not be as independent as it's intended to be. If the same people who essentially comment on the drafts of the commission are also members of the commission and also members of their Sixth Committee delegation. So that's one issue. I don't think the division is as stark. I think, and you'd have to do an empirical study. I mean, I'm Kenyan, I'm a professor of international law, but it is true that generally, maybe historically the professors have been from the West. I don't want to deny that. Partly because also, don't forget, that for much of the Commission's history, it was dominated by the Western European group in terms of special rapporteurs, in terms of those who are having an active engagement. And it also goes to show about the dominance of the study of international law in Western institutions. It's still not very significant. I mean, it's changing a bit, but the teaching of international law in universities in Africa is still very much peripheral. So you need a core commitment to the teaching of international law, to institutions such as this, to get people who engage with that process to have a whole cohort of younger lawyers who can be future members of the International Law Commission. I don't know if that answers your question. So I'm not disputing that Pele is right. Empirically, you'd have to look at it. I think all regions may have a problem, or not necessarily a problem. There are those who say that the commission is only going to be useful and effective if, in fact, those who have practical experience of the needs of states sit in it. That there's no point having 20 members of academics whose expertise is on the theory of international law. The drafts that come out of it will be of no practical meaning or use to the states concerned. That you need that balance. And I think in the commission, I have to say as a practical matter, the balance is very essential. But there have been concerns about independence, especially since there are no rules about disclosure of interest in the commission. You know, I don't have to disclose that in October I will also attend the Sixth Committee as a delegate of Kenya, defending the very issues that were controversial in the commission. And so there's been a conversation within the commission itself that perhaps we need rules of practice and rules around ethics and rules around disclosure, which at the moment we don't have. And it has caused some unease in how the commission operates.
Thank you very much.
I think that's all I want to say about composition, that the GA is very much in the driving seat, that there is deference to political organs. The one exception is in relation to casual vacancies. If a casual vacancy occurs in the commission, for instance, as a result of the resignation or the death of a member, then the commission itself fills those casual vacancies. And this was agreed as far back as 1947. The GA is not involved. States can nominate candidates for casual vacancies. Members of the commission can nominate candidates for the casual vacancies. But the voting itself, which is done by secret ballot, is within the commission itself. Right, just one other aspect of composition. I think states have done very well and rigidly adhering to the question of geographical representation. There's no doubt that the Commission as a whole seeks very much to reflect the different legal traditions and legal cultures within the United Nations. What the Commission has not done very well on is the question of gender representation. The Commission as a whole has had 229 members since 1947. Does anyone want to guess how many of those members have been women? No, 10. So there is a conversation going on within the Commission. I mean, this is a never-ending conversation, that member states have been very alert to the need for geographical and linguistic diversity within the Commission, appropriately so, but less sensitive to the need to make sure that the Commission reflects the international community as it exists. So at the moment, there are 6 women in the Commission, but 6 is also the highest number that has ever existed in the Commission since 1947. Right. The other key aspect, and this is of some relevance as I saw the Secretary General of ALCO, is the Commission was not intended, deliberately so, to be an ivory tower, and that it should have meaningful and active engagement with other bodies that are involved in the codification of international law. This is very much in the statute of the International Law Commission itself. So the Commission has periodic meetings with the Inter-American Juridical Committee, the African Commission on International Law, and I see a member of that commission here, and we also have periodic meetings with the Inter-American Juridical Committee. In one sense, there's been some criticism that these meetings are very much of a pro forma kind, in the sense that the chairman, the chairperson of the African Commission or the chair of the Inter-American Juridical Committee or CADI would come and explain to the Commission the projects in which they are involved to see both areas of overlap, convergence or divergence between these codification bodies and the International Law Commission. But for reasons of time, of resources, what many of us have lamented is the lack of really meaningful engagement between these institutions. And this becomes particularly critical because, as I said at the start, the Commission is required to show deference to states and to essentially submit all its works in progress to states and get feedback from member states of the United Nations before proceeding with the work of the Commission. Now, I see this as a fundamental democratic deficit, that many of these reports come from just very few states. So for instance, in a topic as important and of significance to so many states, you would find that only 38 states submitted reports to the International Law Commission, or rather gave feedback on their views on particular topics on the Commission's agenda. Immunity of states from foreign criminal jurisdiction is a case in point. Now, this becomes problematic because if only 38 states actually give feedback, and those 38 states are predominantly, say, from Western Europe, right, it means that a very large section of the international community are not contributing to the formation of these rules. And if these rules, because not all projects of the Commission end up being draft treaties or some of them are just draft conclusions. They're just commended to states to follow their guidelines and see whether or not it influences state practice. So the key issue here is that if only few states submit reports, and you may well tell me why states don't submit reports in your foreign ministries. I don't know how many of you have actually engaged with writing reports or comments on the works of the International Law Commission that are in progress. So one view, and this is one in which I have taken an interest, as a lot of others, is to use consultation with these other regional bodies. So for instance, if in fact only 2 African states have made comments on the topic of immunity of states from foreign criminal jurisdiction, one argument is that we should use the African Commission on International Law, which has an advisory role as well, to essentially collate the views of African states and present those to the Commission. And perhaps we could have a meaningful dialogue by the way of a joint seminar. and that the same thing could be done, say, with the Inter-American Juridical Committee or with ALCO. I should say ALCO has taken an initiative. There have been ALCO webinars and seminars, but what we need more of is to use these regional bodies as a vehicle to bridge the gap of lack of state engagement with the work of the International Law Commission. Because essentially it means that a large section of the world end up being rule takers and not engaged with the process of lawmaking if their feedback is not fed into the work of the International Law Commission. But the statutory basis of that consultation exists in very clear terms in the statute of the International Law Commission. For those of you who are in foreign ministries, maybe you may wish to explain why you don't engage with the many drafts you get from the International Law Commission invitation for comments. But anyway, that's the state of things that, oh, yes, sorry.
Thank you, Professor. My name is Abdurrahman from Indonesia. I'm actually involved currently in Indonesia's card nomination for the ILC membership. And this is our first time since 2016. We have only sent 2 members, Indonesian members in the ILC, and we are planning to send another one. I think the biggest struggle is more of the lack of international experts in Indonesia itself, as well as the engagement in the form of forums that ILC perhaps should have with the Ministry of Foreign Affairs. But that's just my perspective. Thank you.
Yeah, I think a number of states, including in Kenya, have told me that the lack of expertise, the very few government officials engaged with questions of expertise in international law, and the many demands on 1 or 2 legal officers in New York and elsewhere to comment on this work and present comments to the 6th committee. So there is a question of capacity. And in a way, one of the criticisms that have been leveled against the International Law Commission is that we just fold our hands and say we will only engage or act on the basis of comments we receive from states. That maybe the Commission should try a different approach and be more proactive by doing state visits to gather information and views from those states, especially on topics that are of critical importance, such as immunity of state from foreign criminal jurisdiction. Because it's interesting that those most opposed to the project are also those that have not given any feedback. So if this is going to be a meaningful engagement, then maybe the Commission itself needs to change its strategy of how it engages with governments. That's one suggestion that's been made. I think the more realistic suggestion in the interim to me is to engage with regional bodies in which states take part and quite meaningfully, such as ALCO, the Inter-American Juridical Committee, the African Legal Commission on International Law, for instance. Now, just very quickly, of course, as I said already, that the International Law Commission is a subsidiary organ of the General Assembly. And ultimately, all its reports, all its works must get considered by the 6th Committee, the Legal Committee of the United Nations. Now, the 6th Committee is not, it's a committee, it's one of the 7 committees of the General Assembly. It is not a legal committee in the sense that it does not provide advisory work or does not give advice to the General Assembly as such. But it essentially acts as a bridge between the International Law Commission and the General Assembly. The 6th Committee consists of state representatives, and it is the main committee that considers all the works of the International Law Commission. The Commission is required to submit its reports to the 6th Committee. It is in the 6th Committee that they are debated. And there is a joke within the International Law Commission that the 6th Committee is also the graveyard of all the reports of the International Law Commission, because it is in that context where a decision is taken on what to do with the work of the International Law Commission. They can decide to convene a conference, as they are now proposing to do in relation to crimes against humanity, to adopt a convention. They can decide essentially to take the work forward by realizing the Commission will have provided a roadmap. For instance, the Rome Statute of the International Criminal Court originated in an ILC project, but clearly the project revealed complications that if a court was going to establish, which would both be an institution with a body of substantive law, then the process required much more political involvement. So the Commission provided a draft of a treaty, but that treaty was just a skeleton, a roadmap, on the basis of which the political actors, political negotiators, and state representatives were able to convene a diplomatic conference to consider it further. So one option is, of course, the treaty model. That has now increasingly become an exception. You know, the earlier projects of the Commission, such as the Vienna Convention on Law Treaties, the Law of the Sea Convention, although even that eventually was taken away to a much longer political process, which resulted in the 1982 Law of the Sea Convention. By and large, many of the recent products of the International Law Commission have just been commended to states by way of a resolution to await developments in international law, or by way of conclusions, or by way of draft guidelines, or sometimes they're taken note of without any indication as to what should happen to them, which I can tell you is very dispiriting for members of the International Law Commission after a long project of work. But essentially, this again just goes to show that the International Law Commission has to show deference to the political organs who ultimately are in the driving seat. The Commission has no democratic mandate to decide on the final outcome of these products. That mandate belongs to states sitting in the General Assembly and a power delegated to the Sixth Committee. So before I turn on to the question of immunity, I just very briefly want to talk about some of the challenges facing the International Law Commission in the discharge of its mandate. First is one that I've already referred to, that of course the Commission has to respect the law-making techniques because it's essentially an instrument at the disposal of government. It has no power to make law. But that also means that its task can only be meaningful if states engage with it. The fact that I've already referred to, the Commission is required to circulate questionnaire on its work to states, it's required to circulate questionnaire on its work to UN organs, it's required to consult international or national organizations on the progress of its work, precisely because it has to show deference to those political bodies. The main problem facing the Commission is the lack of engagement with states in the work of the International Law Commission. In many cases, questionnaires are sent and no one gives feedback. The other main frustration is that the lack of initiative. The intention when the International Law Commission was set up was that UN organs, the General Assembly, would frequently ask it to undertake tasks for it, and that those products of the Commission would essentially serve as a roadmap for further work by the international law, by the General Assembly, and by bodies such as that. But this power of referral has essentially dried up. You know, apart from the project on sea level rise, the General Assembly has not asked the Commission to undertake any work of either codification or progressive development. So if you think about it, if you're set up to serve a political master who's not making use of you, that in itself can be quite dispiriting. So there are two aspects: the fact that the power of initiative is not being used by the political organs, and the second limitation and frustration is the fact that these organs, both the General Assembly and other UN organs, and states themselves, individual states, are not responding to questionnaires and are not meaningfully engaging with the work of the International Law Commission. Yes.
Hi, Professor. I'm Zurshida from Malaysia, Attorney General's Chambers of Malaysia. I have one question with regard to the little engagement by government, that point. Just to get your thoughts as to at which stage would a state's engagement with ILC be most meaningful? Would it be by way of intervention at the Sixth Committee during the annual session? Or would it be prior to the ILC come up with its report before it's submitted to the Sixth Committee, sorry. Thank you.
So at all stages of the International Law Commission work, at all stages of the International Law Commission work, it engages with states. So for instance, it's a very complicated process and I don't have time to go into the details. But before any topic is adopted on the long-term program of work of the Commission, it is submitted to the Sixth Committee to get feedback from states on whether or not that particular topic is viable, whether it's ripe for codification, whether there's enough practice. Because if the topic, for instance, emanates from the International Law Commission, the Commission itself is required to demonstrate that it is ripe for codification. Remember the power of initiative to create law de novo where there is no law. Pure progressive development is a power that is reserved really for the political organs. So at that stage, states should engage with the process. If you think this topic is going to be a complete waste of time, don't wait until the Commission has worked on it for 5 years and say, well, we'll take notice of it, we recognize it, and nothing happens, which has happened to some of the topics of the International Law Commission. So at each of those stages, states are in the driving seat. When a topic is to be removed from the long-term program of work to the current program of work, again, there is consultation with the Sixth Committee, and states are required to give feedback on whether this should be a priority area for the International Law Commission. So to me, those are critical areas, because in fact, if most states signal to the Commission that this is not a priority area for them, that this is not a topic they should embark on, then I think a lot of time and resources will be saved. The Commission has embarked on topics which in the long term were also overtaken by events. Remember, one shift again, which again you may want to reflect on, is of course in 1947 when the Commission was created, there were not many institutions that were involved in lawmaking. There was a conversation and a very good proposal to have the Commission look at the pandemic treaty. But as you know, that has been negotiated under the auspices of the WHO and the feeling that that's a context where all the expertise of both lawyers, doctors, experts on epidemiology would be present, and that this was not a proper topic for 34 lawyers whose only expertise is law. Right? But at each of those stages, there is no necessary need for a state to wait until the final product is now being debated on how the Sixth Committee should dispose of it. Should it be a treaty? Should it be a draft conclusion? Because, as you notice, one of the topics I'm going to talk about now, immunity of states from foreign criminal jurisdiction, has been on the Commission's agenda since 2007. So for all that period, states have had the opportunity to influence the content and direction of the topic, right? So there is no point. I think the hope is that the Commission will finish it in the current quinquennium by 2027, but the other challenges facing the International Law Commission, of which the most significant is the absence of resources. We didn't meet for the second session this year as a result of the liquidity crisis in the United Nations. But so specifically, the states should engage with this process at all stages, at the initiation of a topic and throughout the topic's evolution to influence its content and direction, not just at the end when the General Assembly finally takes a decision on what the ultimate outcome of that project should be. I think some of these there are other challenges which have a historical significance, but also retain a particular currency. One of the debates in the International Law Commission, including now, in relation to projects, and all projects in the Commission involve elements of codification, is whose law exactly are we codifying? For much of the Commission's history, this was a hotly debated issue. Part of it was a challenge to the perceived universality of international law, that codification was essentially codifying European hegemony and dominance of the institutions and processes of international law. For historical reasons, which we can debate elsewhere, the Soviet Union, later Russia, were very much opposed, of course, to processes of codification. For them, the treaty was the only democratic and proper way of making law, and that codification was essentially forcing onto states legal rules and norms in respect of which they'd had no chance or role in the evolution of it. There are echoes of this remain in the Commission, even today, partly because if we only receive limited question responses to questionnaire or state practice, and in a way, the Commission is in a very difficult place. The Commission has to respond on the basis of comments it receives from states. But if those comments are only from particular regions, the Commission faces the criticism that it is involved in a very partial codification based on the practice of a very narrow number of states. This has been a particular issue on the topic of immunity of states from foreign criminal jurisdiction. One of the questions that has been raised about aspects of the topic, that a codification, is that the Commission has relied on the legislation and judicial decisions over very few states, mostly in Western Europe, or emanating from Western Europe, and that in a sense, that practice itself is not representative. It remains a particular challenge, and there continues to be a very live and bitter debate around this question and questions of how to engage with states. Many special rapporteurs have said, yes, they could do more, they could be more proactive, meet with government officials, send out delegations, but in a context where the Commission itself is so cashed out, I mean, as I said, we are supposed to meet for 12 weeks, we only met for 5. Special rapporteurs themselves, who are not funded in any way other than the honorarium that we get from the United Nations, say that they are not in a position to undertake meaningful engagement in the form of country visits and engagement with government officials in situ. So it remains a challenge because, in one sense, the Commission has pretty much proceeded on the basis of the very few reports it receives from states, whether in the Sixth Committee or by way of written responses to questionnaires. The other question which has arisen, and also within the Commission, but also in terms of its engagement with the Sixth Committee, is that there needs to be some understanding of what topics the Commission is suited for. There are those who've been very critical of certain topics that have been on the Commission's agenda, that other bodies where there would be expertise beyond law are better suited for those projects. And some of this is related even to projects around law of the sea or environmental topics. And so one argument is that the Commission should only stick to the methodological topics around sources of international law, interaction of sources of international law with each other, and that it should stay clear, for instance, with difficult questions such as comprehensive ban on nuclear weapons or responsibility for historic wrongs or issues of statehood, on the argument that either these are very political in the context of an international system where there's no political appetite for these political topics. So within the Commission, this becomes a very live issue every time that topics are introduced in the Commission or is in long-term program of work about the expertise of the Commission. And if, in fact, the Commission should only engage with the traditional topics of international law, it's also accused of being out of touch. So the Commission finds itself between a rock and a hard place. Either it takes on more ambitious topics, and in respect of which it will be told that it has no expertise in the absence of the ability to engage technical experts. And if it sticks to traditional topics, the argument is that, well, those topics are already are exhausted or have been comprehensively dealt with other bodies. So that's the context in which the Commission work takes place. I think that's all. Unless you have any questions, I want to shift to a particular topic as an illustration of how the Commission works. Yes.
Thank you, Professor. Insights from your experience from ILC. My name is Ayako Hatano from University of Oxford. I have actually two questions. First one is about the point you mentioned on the previous slide. So the sort of historical or European dominating issues in the which is reflected the history of ILC. I'm just curious, the third world approach to international law, that kind of perspective is disregarded in the discussion of ILC, or considered as sort of some, I don't know, considered significantly at some point. In maybe like depending on the topics, I guess. This is the first question. The second question is about non-state actors or even individuals having more voices or presence in international law. Like they're, NGOs is now like engaged in the ICJ proceedings as well. So I'm just curious, I understand historically, like ILC consult with international organizations and governments, but does it also consider, engaging some more individual non-state actors' perspectives or like an engagement of those in now or in the future?
So on the question, your first question about 12 scholarship third world approaches to international law, whether it has any place in the work of the Commission. In theory, yes, in the sense, and that's why the Commission is required to represent the main forms of civilization and legal systems. So, as I said at the beginning, all regions of the world are represented, and that's the one issue that has been rigidly maintained from the very beginning. Initially 15, but progressively moved on to 34 to ensure all legal traditions and legal systems are represented. Obviously, at the end of the day, it's up to members of the Commission if they want to engage with those issues. But there is a particular practical problem, which I discovered and many others did when you go into the Commission. The Commission, by and large, operates by consensus. So if you have any radical ideas that you want included on the Commission's agenda or to be adopted in the context of a particular topic on the Commission's agenda, you'll have to carry your colleagues with you. So whether or not the Commission is as progressive as its members are, and in relation to a body that operates by consensus, in my experience, it's been very difficult to move very radical ideas forward. So we kind of pretty much end up being the middle ground of everything. So basically, if you want to engage with very radical ideas around TWIL or others, you'll have to write your academic article and hopefully sneak it and convince your colleagues. But yeah. What is the second question?
Second question is the engagement of non-state actors.
Yeah. So in a sense, non-state actors, non-governmental organizations, once a topic is on the Commission's agenda, the Commission is required to take perspectives of all actors, non-state actors, individuals. For instance, there is a topic currently on the Commission's agenda on the settlement of disputes between international organizations and private parties. And that has required consideration of issues that would be involved between international organizations and individuals and corporations and non-state actors. It would be interesting to see what direction it goes, because the statute of the Commission, although the Commission is empowered to act primarily in the field of public international law, it also has the mandate to consider questions of private international law if relevant to its work. In my view, and the view of quite a few of us, on the topic of the question of settlement of disputes between private parties, international organizations and private parties, would ultimately require the Commission to consider questions of private international law. But there's been a lot of unease because, with a few exceptions of people who've been unfortunate enough to be forced to teach private international law or study it, the study of private international law is largely in decline, and there's a marked reticence for the Commission to engage in questions of private international law, and also because there's a view that that is the preserve of either the Hague Academy of UNTROL and that it should not engage in questions of private international law. But it remains to be seen how meaningfully it can come up with a framework of remedies, questions of jurisdiction, without considering private international law reasoning or private international law techniques. Okay. Yes.
Thank you for the presentation, informative and very thought-provoking for me. And my name is Yuki Morita from Kyoto University, and I'm a master student. And my question is somewhat theoretical questions. I know your presentation is larger about the practical issues, but I wanted to ask just one simple question. And my question is, if there has been any qualitative change in the working progress of the committee by its codification or not? So, because there has been a lot of works and articles, draft conclusions made by the committee, there has been, it can be said that its work has been changed from the codification, pure codification, to the more interpretations of each works. For example, the 2018, the conclusions on the subsequent agreements and subsequent practice on the treaty relations to treaty interpretations, that committee interpreted the Vienna Conventions to create that conclusion, in my view. And there has been a change in that sense. But I want to ask the professor's opinion on whether that change was a qualitative change in the process of the discussions within the commissions, or if there is no change. I would like to.
I hope I've understood your question correctly. You're asking if the commission's shift towards methodological topics on interpretation of international law has changed?
I'd like to ask rather than the change of the topic, but the methodology itself, how the committee made the change, make its conclusions on the draft of the treaty.
So I think, if I understood it correctly, one, the Commission has spent a lot of time on methodological topics, right? On general principles of international law, on identification of customary international law, on fragmentation of international law, and on subsidiary means of international law. So those are sometimes called largely methodological topics, giving a guidance as to interpretation of existing rules of international law. The change in that sense is that in relation to those methodological topics, they're never going to lead to a convention, right? So the outcome of any of those can be guidelines or draft conclusions, and they're commended to states, for instance, the Commission's work on subsequent practice and subsequent agreements, and the relevance of subsequent practice, subsequent agreement on interpretation of treaties becomes very relevant. I mean, I've recently had occasion to look at it in the connection of the ILO dispute before the International Court. So, yes, because the law in this area is already developed, and because the Commission has no mandate to overhaul it, all it can do is provide guidelines in the interpretation of existing rules. And that's why, with the exception of crimes against humanity, where in fact that was from the very beginning in the form of draft articles. And by the way, immunity of states from foreign criminal jurisdiction is also being drafted in the form of draft articles with a view to a convention. So states will have to iron out the political differences to come up with a treaty. But beyond that, many of the Commission's topics, methodological topics, are the work of a study group, say on sea level rise, and they will submit report to the Sixth Committee. And that committee will decide on the final outcome of that. In most cases, they will take note of it, or they will commend the conclusions or guidelines to states to use in practice without taking a view on it, in the hope that those guidelines either confirm practice or will crystallize or will make it clear for end users what the interpretation of rules are. So I don't know if that answers your question.
Thank you. May I ask just add one thing? So is that correct to understand that there has been no change in the discussion or methodology of the discussion within the committee itself to create the new conclusions? Is that right?
To create a new conclusion?
I mean that in order to make the Vienna Convention, for example, there has been a codification, pure codification rather than the interpretations of the codified international law. But in terms of the draft conclusion in 2019, it was the interpretations of the Vienna Convention rather than pure codifications. But I'd like to ask if there is any qualitative change in the work or the discussion itself by the committee.
So the Commission takes the view that the boundaries between interpretation, codification, and progressive development are very permeable, that there is no rigid one. In each case, it depends on a particular rule in question. For the reasons I gave earlier, no topic is completely new, no issue is completely new when it comes to the Commission. All topics involve elements of progressive development and codification, and any process of codification involves gap filling. Right? Maybe this comes clear when we look at the question of immunity of state from foreign criminal jurisdiction. There's one whole section on procedural safeguards is seen by many as progressive development for which there is very little support in state practice, and that's why it's been very controversial. Okay.
Sorry, one more question.
Okay.
Here. I read that due to budgetary constraints meeting between ILC and regional bodies such as ALCO have been reduced during the ILC sessions. So in your view, how is the current international situation affecting consultations between the ILC and regional bodies? This is the question.
So, in a sense, this year there was no consultation. Not ALCO, not CADI, not the Inter-American Juridical Committee. Now, in a sense, that's to be regretted from a very practical point, in the sense that those bodies come to Geneva every year, and there are many areas where we work on common topics. So, as I mentioned already, there's a fundamental limitation in the fact that states don't engage enough with the work of the Commission. And say only one way of getting meaningful reaction to what we are working on is, for instance, to get the views of the African Commission on International Law, or ALCO, or what their member states say to them. If the Inter-American Juridical Committee is working on an identical topic or questions of reservation, then luckily for the Inter-American Committee, some of the members of the Inter-American Committee are also members of the International Law Commission. But that meaningful discussion is very, very crucial if the ILC itself is to remain relevant. Because remember, from the very beginning, the idea was that codification was only going to be meaningful if it was anchored to the practical needs of states, so that you bridge the gap between the theory and the practice. And one way of that is to look at the work of these regional bodies and to have input from regional bodies. ALCO has been trying to do that by way of webinars and other conferences, but that meaningful engagement where they literally come to Geneva to present the work they're doing and to examine areas of convergence. In my view, we should probably even have more of those engagements, not just in the form of an annual presentation, but perhaps a workshop where there's meaningful dialogue between all regional bodies and the International Law Commission, especially in a situation where we face genuine problems in getting feedback from states.
Thank you.
Good afternoon, Professor. I'm Chang.
To speak up.
Yes, I'm Chang. I'm from Tohoku University. I'm from Vietnam. Following the question made by our colleague from Kyoto University, I'm curious about the dynamics and the interaction between the ILC study group and the broad commission in dealing with a certain matter. For example, the work of the ILC study group for the sea level rise, for example. How could the study group trying to address the divergent views from other members from the broad commission, and how to balance and reflect diversion at the same time to make sure that the outcome of the study group could also reflect somehow to appeal to be as a consensus base of the whole commission as a whole.
Yeah, so you may have to save your question for Niloufar Oral, who chaired the study group itself. But just to answer your question more immediately,
I understand.
Is, of course, the study group is an open-ended study group. Anyone can be a member of the study group. You sign up at the beginning if it's of your interest, if you feel you'd have to contribute. If you don't have, there are many things going on with the commission, so not everyone is a member. But remember, every report of the commission, every study group, or any project has to be adopted by the full committee. So we literally go through the report of the study group line by line. And that's a chance for any members who've not participated in the study group itself to essentially feed into the final report before it's submitted to the sixth committee. So in a sense, it's a report of the whole commission. Whatever outcome, whatever process is involved, whether it's a working group or a study group, the ultimate report has to be adopted by the full commission. It's always a very boring process, because if you're a member of the study group and you've taken part in all the debates or the drafting committee, you know that that particular text will have to come back before the plenary session and to be read line by line for adoption. So there is a chance for every member of the commission to claim ownership and to feed into those processes.
Yes, thank you very much. My question is actually originates from the fact that I'm writing on sea level rise, and my professor, he's always very emphasizes on the fact that I have to precisely quote the report of ILC study group, not the ILC in its entirety. That's why I really wonder whether that is that like really a true matter, or that is somehow also reflect the committee as a whole, the commission as a whole.
We can have the conversation. The reason why he's telling you that is, of course, the report of the study group will indicate the divisions, areas of convergence or divergence as the matter is debated. The final report that is submitted is essentially a summary of all these conversations. So in the same way that you want to look at the chair's report of the drafting committee and the debates in the drafting committee, not just a summary report which is finally submitted. The report of the commission is a summary and does not always reflect the areas of disagreement within the particular committee. So if you look at the study group, it will reflect where members agreed with a particular proposition and what they disagreed with. So yes, if you're writing a thesis, you have to go and look at the debates within the study group and not just the report that's submitted. Okay. I'm conscious, I stand to be guided how we are doing on time. So end time is 5:55. What time is it now? Okay. So I'm told I have 20 minutes. Since we have only 25 minutes, I'm going to be very mean and we're not going to even have a 5-minute break. To just very quickly go through a particular topic, which I thought illustrates very well how the Commission works, the challenges in the Commission's various projects, and where things are. So, immunity of state officials from foreign criminal jurisdiction. Just very briefly, this was adopted on the Commission's agenda in 2007, and it is the longest project on the Commission's agenda. We were hoping that it would be finished in the current quinquennium, which is 2027, but again, we're in the hands of governments. The liquidity crisis is outside the Commission's hands. We'd ask, our last 2 sessions have actually been short sessions. In 2024, we were supposed to meet for 12 weeks. We met for 10. And this last year, we met for 5 weeks instead of 12. So whether or not the work will be completed in the current quinquennium is up for grabs. No one knows what the financial situation of the UN is and what will happen next year. There have been 3 special rapporteurs. And again, just to illustrate how this works, is when the Commission adopts a topic on its current program of work, which means it will have gone through the various processes we talked about. The 6th committee will have given a nod that the project is ripe for codification, that there's enough practice, then the Commission takes it on. And this was taken in 2007. The first special rapporteur was a Russian jurist, Roman Kolokian, and the next one was Madame Escobar Hernandez, who was in the Commission between 2012 and 2022 and submitted 8 reports. So that tells you, firstly, just how controversial this topic is. In fact, I'm told that the first special rapporteur had hoped that this would be a very straightforward matter, which would be wrapped very clearly and very quickly. But no, that hasn't happened. So the current special rapporteur was appointed in 2023. And he has, the Commission had adopted the text of the project on first reading in 2022. In 2023, Professor Grossman was appointed as special rapporteur, and he has presented the 2nd report. Now, the way the Commission works is once it's concluded a project, it produces a complete set of first reading, which is then submitted to states for comment. After the first reading, the general assumption is that the project is very much complete and that the very minor changes should be made to the project, because otherwise you'll never make any progress. If every new special rapporteur, any new membership of the commission comes up, then the commission cannot essentially have a reset button where with each new membership it changes direction and starts all over again. So the general understanding is once a project has gone through the first reading and adopted through the first reading and submitted to government, the only changes that will be made to the topic will be on the basis of comments received from states. Of course, as you can imagine, in relation to a topic as controversial as immunity of states from foreign criminal jurisdiction, many of us were slightly uneasy about this because at the last election, the Commission changed membership. 18 of the 34 members were new members. So our feeling was, given the many political changes that have occurred on the question of criminal jurisdiction, we could not just be expected to rubber stamp procedures that had gone on before we arrived at the Commission. But actually the rules of the Commission are very clear. Each new Commission has to continue with the work on the basis of what has been accomplished before, on the argument that if each new Commission could press a reset button and start from scratch, the Commission would never make any progress on any of those topics. So that's where immunity from criminal jurisdiction was. Given that we have very limited time, I will just very briefly talk about the core elements of this project and why it has proved so controversial. So the general idea is a recognition within international law that certain officials of state, in order to be able to effectively exercise their functions, should be immune from criminal jurisdiction. And in fact, the project is only concerned with immunity from criminal jurisdiction. It's not concerned with immunity from civil or administrative jurisdiction. This has been the most controversial area. And so the broad objective of the topic was to codify and progressively develop international law rules applicable with respect to the immunity of state officials from the criminal jurisdiction of other states. Again, part of the controversy stemmed from the fact that those who, only a few states really are in a position or have generally exercised that criminal jurisdiction over state officials. So there were arguments and undertones that has permeated the project throughout its existence, that criminal jurisdiction over foreign officials is the new form of legal imperialism. That in a sense, unfortunately, many of the cases examples cited was between states that had had, say, a colonial relationship. So one argument here was essentially that that immunity from criminal immunity should be the norm, and that exceptions to immunity should be very exceptional, because in the absence of clear rules, criminal jurisdiction could be utilized for politically motivated reasons, and that the circumstances in which foreign state officials could be subjected to the domestic jurisdiction of a state, whether on the basis of territorial jurisdiction or universal jurisdiction, should be clearly stated, right? And so the presumption is one of immunity, to which there were exceptions. So two general theoretical frameworks underpinned the whole discussion on immunity. And the idea here was that there is the question of personal immunity, that certain officials, because of the office they hold, should be immune from the criminal jurisdiction of states while they hold office. And this has been referred to as immunity ration personae, essentially personal immunity of certain persons who hold office. A related concept was functional immunity. So personal immunity was to subsist as long as the persons in question held office, right? The related one is that in relation to certain conduct, where the person in question was exercising the functions of the state, the immunity belongs to the state, and therefore immunity continues even after the person leaves office, so-called immunity ration materiae, that because your conduct was by virtue of the office you hold, because you are exercising essentially governmental functions, those governmental functions continue to enjoy immunity even after you leave office, immunity ration personae. So that was the broad framework in which the debate was conducted. Now, controversies. The first question was for the Commission to agree which officials of a state should be entitled to claim immunity from criminal jurisdiction. Clearly, the need here is to balance the twin demands of sovereignty, the need to ensure that international relations continue so that your foreign minister is not worried every time they attend an international law conference in Tokyo that they may be the subject of an arrest warrant, and the need also to ensure accountability or respect of the jurisdiction of the forum in respect of matters which are properly within its competence as a matter of criminal jurisdiction. So the whole project is an attempt to balance these competing concerns, to respect that certain persons by virtue of their office should enjoy immunity while they are in office, and that that immunity may also or should continue even if they leave office if the conduct in question was exercised by virtue of the office of the state, that the functional immunity, it was an exercise of a governmental function, not personal. These are all very difficult and loaded questions. So the first question that the Commission, that has proved actually surprisingly controversial, is who should enjoy immunity? Which state officials should enjoy immunity from criminal jurisdiction? Yes.
Thank you, Professor. I wonder why this delicate matter is being under discussion now when the statute of the International Criminal Court is already in force, and we know that the International Court has jurisdiction, criminal jurisdiction over officials of the various states. So I wonder why it's being under discussion now. Thank you.
Let me just state a few preliminary matters. This is concerned with the relationship between states, with the state exercising jurisdiction against foreign officials on the territory of that state, a forum state and the state of the also putative victim state. It is not concerned with those situations where international criminal courts exercise jurisdiction, because those are already dealt with under the treaties that establish those institutions. It's also not concerned with diplomatic immunity or immunity of those under special missions, because those are also dealt with under existing international treaties. So the Commission was not intending and has no mandate either to supplement or to, as it were, upend the agreements already reached in relation to those international treaties, right? It's only concerned with states exercising criminal jurisdiction on, against foreign state officials, either on the basis of universal jurisdiction or on some other basis in relation to crimes committed on their territory. Now, as a matter of general international law, of course, states have criminal jurisdiction in matters occurring in their territory. Much more controversial is universal jurisdiction. But even in relation to those instances, there's a general presumption that certain officials, while they're in office, enjoy immunity from the criminal jurisdiction of states. That's, the first question is which officials? The Commission, on the basis of state practice, and this is very controversial, has reached the conclusion that only heads of state, heads of government, and foreign ministers enjoy immunity on the basis of what they call the so-called troika. I think the commentary will probably reveal some disagreement, but at an ALCO conference, on the very question of immunity, a number of states who are participating expressed the view, for instance, that in certain systems, they did not necessarily see why defense ministers should not be able to claim immunity. The other argument is that it showed an insufficient understanding that states may be organized differently, that in certain states, for instance in the Middle East, religious leaders may actually have authority to exercise governmental functions or functions that in other states are exercised by foreign ministers. So that by limiting it to the troika, right, one argument was that the Commission had not been sufficiently sensitive to the practice of particular states. Again, the problem here is many states that made these arguments never submitted comments to the Commission when it was considering this topic. There are those who felt, and I think there have been very extensive reports on the Commission's work in relation to this question of who's entitled to immunity, is that in general, immunity should be an exception, and that we should not broaden the category beyond the troika, heads of government, heads of state, and foreign ministers, who, by virtue of the offices they hold, should be able to claim immunity, at least when they are in office, so as not to be impeded from the official duties that they have to carry. But you may this is something you may want to think about. The Commission is still considering these issues, whether or not that limitation is a valid one just to those two officials, or should it also, in certain instances, extend to foreign ministers or some other officials who, within those legal systems, exercise functions that are equivalent to those of a head of state or a head of government. The second controversial issue, and I'm now just skipping because I'm very conscious of the time, that gave rise to controversy is the exceptions to immunity. In draft Article 7, let me see if I can skip to that. Yeah. In draft Article 7 of the articles that have been adopted by the Commission on second reading, the Commission took the view that no one should be able to claim immunity, ration materiae, if the conduct in question amounted to genocide, was a crime against humanity, war crime, crimes of apartheid, torture, enforced disappearance, slavery, slave trade, or aggression. And here I'm skipping a provision with a background of extreme controversy. In 2022, the Commission was unable to agree on the text of this particular provision when the draft articles were adopted on first reading. Many of the members, or some members of the Commission, you can go back and read the reports, felt that aggression was always open to politically motivated prosecutions, and that heads of states, heads of government, or foreign ministers should not be subject to the jurisdiction of any state in relation to, say, the crime of aggression. On the other hand, there are those who felt that aggression was the original crime at Nuremberg, a crime against the peace, and that it has a very firm footing in the lexicon of international criminal law as one of the core crimes in respect of which no immunity should be granted. The argument that the Rome Statute had already adopted this in Article 5, and that there was no argument at all for excluding aggression from the list of crimes in respect of which no immunity can be claimed. Within the Commission, there were those who felt, and so here the divisions and tensions become quite apparent, that states from the global south are more likely to be accused of genocide or crimes against humanity, of enforced disappearance, and would not be able to claim immunity, but that those in the global north were more likely to be accused of aggression, and that for which they would be able to claim immunity. So there was an argument that there were double standards in the way this provision had been drafted. In the event, and in a very, very rare move, the matter was only adopted by way of a vote. As I said from the beginning, the Commission operates by consensus. And so there was a very narrow majority in favor of excluding aggression from the list of crimes in respect of which no immunity can be claimed. Now, of course, as we all know, there have been huge changes in international law, in the development of state practice, and questions have arisen, including those who had opposed this maybe had had time to reflect between 2022 and 2025 whether the exclusion of aggression was really warranted in the context of a progressive instrument such as what the Commission was proposing. You may want to look at the debates in the Commission on this question, but the general view is that in the second reading, which happened this year, aggression is now in the list of crimes in respect of which you cannot claim immunity. And again, I have skipped over a very controversial provision which had a long, long backstory, but that's where the Commission is now. So in respect of Article 7, these are the list of crimes which have been included. The Commission on second reading has added slavery and slave trade. What then proved more controversial was the Special Rapporteur on both the first reading and second reading did not define these crimes, but appended an annex of the conventions in which these crimes have been essentially described. So the Genocide Convention of 1948, for instance, the 1973 Apartheid Convention, conventions on slavery and slave trade, and this now became another battleground. A number of members argued that some of those conventions had not been ratified by them. That also included the Rome Statute, and that they did not want to be forced, as it were, through the back door to accept the definitions contained in conventions to which they are not parties and to which they had objected. So then there was the question of the annex. If you're going to have these treaties, if you're going to have these crimes in respect of which no immunity can be claimed, was the Commission going to define them? And was it worth the Commission's time to take that definition when they were already defined in treaties? But the annex was a red line for most members, and as I said, the Commission operates by way of consensus, so there is no annex. One other issue that there were many also who did not have strong political objections, either on the basis of ICC, but just felt that the annex would freeze developments in the law, that states may want to prosecute on the basis of customary law and not on the basis of a treaty. And in that case, if the only definition was that contained in a treaty, that would be unnecessarily constraining. The example given here was South Africa. South Africa, in 2024, had its first prosecutions for the crime of apartheid. And they had to prosecute on the basis of customary international law, not the convention, because surprisingly, South Africa had never ratified the 1973 Apartheid Convention. And also because it was prosecuting in relation to conduct that occurred before ratification, the only basis on which it could prosecute was on the basis of general customary international law. So the compromise is Article 7 has broadly been accepted on second reading. The list of crimes has been, in respect of which you cannot claim immunity, now includes that list, but those crimes are not defined. And I'm sure that's where we stopped. Our 5 weeks came to an end. The question is, there were those who argued that this is problematic. You cannot, in the context of a criminal provision, provide that there can be no immunity in respect of these crimes and not define what those crimes are. That it also opens the door for potential abuse by expansive readings of what those crimes are so as to essentially expand the scope of non-immunity claims. I have 2 minutes. And, okay. So part of the compromise that was reached on first reading in 2010 was essentially that if, in fact, the scope of immunity was going to be restricted, and we were going to have a long list of crimes in respect of which, international crimes, in respect of which the Troika, head of state, foreign minister, could not claim immunity, then there was a need for procedural safeguards. Procedural safeguards that would protect these persons from abuse of process, that would ensure and guarantee due process in the processes of trial. The question then became whether or not these procedural safeguards had any basis in state practice or in general international law. The Special Rapporteur himself acknowledges that by and large, these were aspects of progressive development of international law rather than its codification. This has proved controversial. Controversial because there are those who argued that the Commission did not have any basis on which to proceed because there was no state practice requiring these particular requirements. I want just to talk about draft Article 10, notification of the state of the official. And this is the one that proved controversial. That provision in full states that before a person is prosecuted for any crime within the jurisdiction of the forum, the state of which he's a member, and so I'm talking about here in relation to the Troika, should be notified that a prosecution is about to commence. In fact, at any stage of the process, including gathering of evidence or beginning of investigation, should be notified that these procedures are about to take place and be given a chance to comment. That had proved very controversial on first reading. It proved even more controversial on second reading because states themselves were divided on this. There were those who felt that this requirement of notification was a practical necessity in a political context where states would need to transact international business and not be ambushed by prosecutions over which they had no information of. There are those who argued that this was essentially the end of accountability. If you notify a state that you're about to open investigations against certain officials, there is a risk of tampering with witnesses, there's a risk that evidence would disappear, there's a risk that the whole process would essentially collapse. And one of the criticisms was that there was no evidence in practice that this notification had been required before the opening of investigations, that the existing treaties, including the Torture Convention, had required that notification, but after a process whereby the person was already in custody, essentially to safeguard the integrity of the process and make sure that it could continue. The Special Rapporteur was, of course, sensitive to this, and he argued that perhaps notification becomes a requirement, except in situations where there is a risk that the evidence would be tampered with or that the whole process would be undermined as a result of a process of notification. That's where the Commission stopped its work. I think we are going to continue the debate on those provisions when the Commission reconvenes, but that remains very controversial, and that particular provision, in fact, the whole section on procedural safeguards, has been very adversely commented on by many states who felt that it was not grounded in practice and that the Commission had not been sufficiently sensitive to the twin demands of accountability and also respect for sovereignty. So you have a division in the report. There are those who felt the Commission was going far enough and would want notification. Absolutely. There are those who felt notification was going to undermine the entire project of accountability for international crimes. But I think I've run out of time. It's 57, 2 minutes over. I'm not even sure I can take questions, or maybe we can have them in the reception. Thank you very much.
Yes, and please send Professor the round of applause.